said, we're not finding the clerk anywhere in the world and give it to her. It is fine.
So you're following it at 12:59, we're going to hear it at 1 o'clock. So tell your Atlanta buddies how to put things out there.
Observation. Right?
Right. Oh, I didn't think of that. Fair enough. Channel 2
What was that? Channel 2 report on Channel
I'll ask Are we on the record?
Yes, sir.
Yes, Mr. Bowles, what you just filed, I downloaded what you emailed yesterday. Is it the same thing?
Identical, Your Honor.
Are y'all ready?
Yes, sir.
Okay. Let me just tell you that we've got just a few minutes. I'll give you 30 minutes, both sides. So if there needs to be information past that, I'm going to tell you to put it in form of a brief, or if we have to gather together again, we will, but it won't be until next week. So you can be guided by that. I mean, I've looked at the motion and your cover letter. I haven't studied the exhibits, the exhibits that dealt with some back and forth, I think, between the state and your office. I don't want to look at that much, but past that, if you want to tell me what you think I need to know, that would be fine.
Well, thank you, Your Honor. I'm Derek Bauer. I'm here on behalf of WXIA TV and two of its news reporters, Kelly Richards and Jerry Carnes. They are two news reporters who were subpoenaed by the state in this matter for testimony related to their news gathering activities. All of the relevant facts and law that you would need to decide this motion, I submit, are in the paper that was filed minutes ago, but which copies were sent to the court yesterday afternoon. So if we need to cut anything off the rest of the papers, I think you have what you need. It's not a complicated issue. We believe that both subpoenas are due to be quashed under Georgia's Reporters Shield Law. I know the court is familiar with that law. It has enforced it in this case in pretrial proceedings. The first subpoena that was issued by the state that's at issue is to WXIA reporter Doug Richards. It relates to his being present for Mr. Hood's surrender, which the court likely knows was televised live. Mr. Richards was there along with dozens of other reporters and scores of onlookers and scores of law enforcement personnel, but he is not a TV cameraman. He did not physically record the surrender or broadcast it. Again, he was merely present, like many others, for the event for which his testimony is sought by the state, as we understand it from discussions we've had with the DA in efforts to resolve the subpoenas. The second subpoena is to WXIA reporter Jerry Carnes. This subpoena relates to a jailhouse interview that Mr. Carnes conducted with Mr. Hood. That interview was conducted by telephone. It was recorded by the jail, and we understand the state has that recording, and it can be and should be authenticated by the jail records custodian. Both subpoenas seek information from reporters who were engaged in protected news gathering activities. They were covering the story of Mr. Hood's surrender, arrest, and pretrial proceedings. Both reporters continue to cover this story in their professional capacity. The Georgia Reporter Shield Law is intended to protect reporters from having to testify in such circumstances. The privilege is qualified, Your Honor, but the bar is very high. To overcome the privilege, the state has the burden to show that the information it's seeking from news media reporters in these two subpoenas is 1, material and relevant, 2, unavailable from other sources, and 3, necessary to the prosecution of the charges at issue. And candidly, Your Honor, we don't believe that either subpoena meets any of these factors in either case. With respect to Doug Richards, who was present at Mr. Hood's surrender, he cannot authenticate the video any more than anyone else who was present at Mr. Hood's surrender could do. There are numerous other witnesses who can testify about what Mr. Hood said or did when he surrendered. It would be inappropriate and unnecessary for a news reporter, particularly one who continues to cover the case, to be called to do so. So the state has sources available elsewhere, whether from law enforcement or other witnesses, to Mr. Hood's surrender to get the same testimony that it's seeking from Mr. Richards. We also think that the testimony would be totally immaterial. We understand that in various pretrial proceedings and in the trial of this case, Mr. Hood has confessed to the actual acts, the actual shootings. The issue in this case is instead his state of mind or other justification for the shooting. There is no need we would submit for a news reporter to have to testify in this case that he heard a confession that others have heard and that defendants admit, or that there were actions taken by the defendant that he has otherwise admitted. We understand the position the state is in. We respect the state's desire to get video of Mr. Hood's surrender into the case, and whether we have an opinion about the relevancy or materiality of that evidence to the case or not, we have offered to the state an alternative to aid it in getting that testimony, or that evidence rather, into the record. We have offered a records custodian to authenticate the broadcast. Mr. Richards, again, cannot do that. But there is an appropriate records custodian at WXIA who could, and provide an affidavit that meets the hearsay exception, business record exception, or if that's not admissible and insufficient for the state's purposes, we've offered to provide a records custodian for the limited purpose of authenticating the video and to provide a certified copy of the video. And the DA has not understandably had an opportunity to, I think, fully process that alternative proposal given his other obligations here. But we have made that offer, and that alone we believe should be sufficient to meet any obligation WXIA could possibly have to aid the state in obtaining the information it seeks to obtain through these subpoenas. The second subpoena to WXIA reporter Jerry Carnes. We understand from Mr. Malden that the state wishes to obtain this testimony to learn the circumstances which led to the interview between Mr. Carnes and Mr. Hood. That is clearly news-gathering activity, how a reporter got his story. That's subject to the privilege. There's no basis to overcome it here. The state has the audio. The state can authenticate the audio with their jail records official. Anything else the reporter could possibly say about how he got the interview is immaterial to any charge and issue in this case. And in any event, there are other avenues that the state has not explored to get that information, even if he could show it's relevant. He could subpoena Mr. Hood's family members to determine what efforts were made to assist him in obtaining access to the news media for interviews, including that interview. And we understand that hasn't been done. Now again, how Mr. Carnes got an interview with Mr. Hood, how that could be relevant, much less material to the charges that this court is addressing, is lost on me, Your Honor, but the Shield Law nevertheless required the state to exhaust alternative sources for what it seeks before seeking information from the reporter. So for all of those reasons and the reasons contained in our brief, the exhibits there too, Your Honor, WXIA will submit these subpoenas are due equash. WXIA will honor the proposal it made to the state to provide an alternative source for authenticating the video, including providing a certified copy of the video of Mr. Hood's surrender. But the subpoenas are inappropriate and improper, and Georgia's Reporter Shield Law should preclude them. And I'd like to reserve 2 minutes for rebuttal. Thank you.
We had time. That we were being time. But 2 minutes, I didn't know Judge, first of all, he mentioned something about Jerry Carnes going on vacation July 5th. He emailed me today. I called him this morning, and he emailed me later. He's going to be back tonight at the 14th. I certainly don't intend. I'm not going to mess up somebody's vacation and so forth. So we would not expect to get to Jerry Carnes or get to that party, perhaps certainly before that. You know, so that shouldn't be an issue. Let me address this. You have 2 different events that were shown on TV. We basically got, first of all, the surrender on the night of March 25th, broadcast by WXIA, and some other stations as well, and some other feeds, because they were, I think they were the primary feeds. And Doug Richard was the reporter on scene. And at that time, he is not shown. He basically is, at that point, as the defendant comes out, at the point he poses a question to that. And indicate who's posing that question. So he's posing that question to which the defendant responds. So understand what you have there. You also have the defendant at some point having a conversation with Gary Carnes. And that was broadcast by their station. And there was a build-up to it also. I don't recall exactly what all that said or what was prefaced by all that stuff, but I feel fairly certain of and correction if I do, that there was talk about, him calling in, touch base with them. He wanted to get up, speak to them. In other words, the defendant called them. Gary Carnes wasn't calling him. He wanted to basically conduct this interview, and that was how it got started. And it was broadcast at that time. To which meant Mr. Carnes was on TV, basically being broadcast at that point, and he's being questioned, and Mr. Carnes on occasion asked him questions. So understand the context. Both of those matters were broadcast. We have never requested anything about confidential information. We've not requested anything. And Mr. Bauer, and we've had very continual relationship and discussions with that. I know that Mr. Carnes, I probably could have told him that, I guess, with that, but I understood his urgency of trying to get this done. But he talks about this privilege under 24.508 that previously been codified under 24.930. Qualified privilege. It is a qualified privilege. But in that section, he's talking about a section that talks about is it material and relevant, cannot be reasonably obtained by alternative means if it's necessary for proper preparation. But you've got another section of that that's being completely ignored. And it basically is, unless it is shown that this privilege has been waived, and then it says, or that what is sought is material. He's talking about that second section that would somehow abrogate the qualified privilege. But if it's been waived, you don't do any of those. I think we meet all of those anyway. But you don't do any of those. Now, I've got a case, there's really not much citation on it, to be honest with you. And I've got a copy for the court and other parties. Bateman versus Summit Logistics Services at what I have here is 2013 U.S. District Lexus 50692, and I've got a copy of the case. Do that. And on the second page there, it talks about the waiver. Under head note 1, on page 2 of what I gave you, it talks about on the top, on the second column, the waiver may occur when the news person publishes the confidential information or voluntarily testifies. The publication of part of the information gathered does not waive the privilege as to all the information gathered. We're looking at basically dealing with the information that was published and it was made known. And it was clearly waived by the news organization and those reporters at that time, when they basically were interjected into this particular case, one of them on the night of the defendant's surrender, where they were interjected and at that time asked a question. This wasn't one where they were just simply recording it. This is one where the reporter asked the question. And it's certainly necessary in that situation to show that, in fact, that was a reporter who was asking that question. So it clearly was waived under that code section. And with Jerry Carnes, it clearly was waived and edited. We're talking about information that they actually conducted. All that was waived in that regard. For Mr. Carnes to testify about what they waived, what it is that they published in that regard, and where he wound up indicating how that call actually came about, and to really say that this is Jerry Carnes. So clearly there was a waiver. Irrespective, the second part is met also, Judge, in that because it certainly is material relevant and it involves basically the defendant's statements there. It's material and relevant. It gives versions of place of what he says may have happened. And it cannot legally be obtained. He indicated, of course, there could be a certificate for a news broadcast. I don't believe the certificate would do. I think the records custodian would have to come in if you're actually going to go that way. But the problem you have is being able to actually say who that particular person was, that was actually doing the questioning on that day. Who was that on the night of the surrender, as well as conducting that interview. So there are certain aspects of that that could not be reasonably obtained through that alternative means. So clearly it's necessary in proper preparation of our case, meaning all statements of the defendant in that regard that they may not be used in this matter. First and foremost, I would suggest to you, the courts recognize there's a waiver. It's in the code section. It's been completely ignored and not discussed at all since hours of the XIA. And I would suggest that what they published and what they did describe about how they came was clearly waived on these instances there, and you don't even get to the second way in which that particular shield law is so that's our position.
Before you respond, Mr. Hood, do you have any response?
No, sir.
No, sir.
No, sir.
And also, let me ask Mr. Malden, are you seeking evidence on anything other than what has been published?
Nothing more than what's been published, and perhaps that constitutes a waiver of what they're doing. We weren't trying to go into all kind of other information. But for example, where Jerry Carnes indicates how this call came about, to ask him how did the call, because we want to tell you how the call came about. So tell us about that. How did this come about? That call.
Does he say that in the publication? I don't know.
I believe that was part of all that, Judge. If I'm not mistaken, I'll stand corrected, but I don't think it was just an idea. We're going to be here. We're just going to play this call. And I apologize. I didn't have a chance to look back at it before look back at that particular broadcast between the time we got this and this hearing today. But I'm looking to basically get out what I believe they basically published. That's what I'm looking to do. Get out. I'm not trying to get into any of the reporters about all the other dig into anything else they may have done, get into any confidential sources of news gathering information at all. But what they legitimately published and broadcast and dealt with at that time. Doug Richards is on the scene. Are you on the scene? Was that you asking the question? No. Was that the response? Was that what you heard? I mean, there's not a lot to that. And then with Jerry Carnes, the same way, how did this interview come about? What did you do? I certainly would ask them referential questions. State your name, where you employ, what your job is, and then get to that particular date. But other than that, we need to go into what was published. There's clearly a waiver on those two matters. I don't intend to get into all kinds of stuff. Tell me about everything else you've done here. Tell me, I'm not getting into all that. I don't intend to. I'm getting into those matters. That's why we subpoenaed them, because they published them. They published them. They were broadcasts. They were newscasts that people saw. And we've heard that people saw them. Your selection otherwise. Yeah, what people saw in her.
So, Your Honor, I think we have a very narrow issue now, and what was published is not the question. And the case that DA's handed you really illustrates where the disagreement is and how the law is quite clear that he's not entitled to the other aspects that he just told you he wants to get into beyond what was actually published. He summarized what he wants very nicely, what they published and what they did. And he's entitled to what was published. And what I'm telling you is we'll give him the video and somebody who can actually authenticate the video, what was published, which Mr. Richards cannot do. And he already has the audio that was broadcast by WXIA, and he can authenticate that himself through the jail records custodian. Interestingly enough, WXIA does not have audio of the entire conversation. They'd only had part of it because of a malfunctioning equipment. The jail, on the other hand, ostensibly has it all. If he wants what's published, he's got it. So there's no need to take a reporter who's actively covering a story and has to credibly report on a story to the public, including the ongoing proceedings here, put him in the witness stand to say that was me on the phone. It's not material and necessary to anything in this case. He can accomplish anything he wants and more by playing that audio, which he can authenticate himself to the jury. And I would submit that causing a reporter to step outside of his professional news gathering responsibilities and get on the stand in a criminal case in which he is actively covering it as a member of the third estate, you've got to have a higher showing of materiality and relevance to put him in that position, because it takes away the reporter's credibility in reporting on the story. He's now part of the story. Again, all of what he wants, he's already got. The case that he cited to you makes the point that the only thing that's waived under the Georgia Reporter Shield statute is what is actually published. And again, he's got what's published. What he wants is what hasn't been published. How did you get the story, Mr. Carnes? How did Mr. Hood contact you? Now, why that's relevant again, I don't know, but it's clearly outside of any waiver argument according to the very cases that the DA cited, and we've actually cited the same cases in our brief. And again, if what he wants is to authenticate what was broadcast so the jury can see what was said when Mr. Hood surrendered, he can do that without putting a news reporter on the stand, and we've offered him a mechanism to do that, and that ought to be sufficient to avoid the subpoena to the news reporter. I also just want to close by saying I'm not sure why putting a news reporter on the stand to say you're the one who asked that question is remotely relevant. Presuming that the video itself is authenticated appropriately and admitted, does it really matter to the charges that this jury is considering who asked the question? I don't believe it does. If it is material, it's marginally material and not sufficient to overcome the news media's First Amendment right to prohibit its news reporter who's covering this trial from sitting as a witness in it. Thank you.
Yeah.
I don't want to argue that. I do want to clarify. We're not seeking to put the jail recording. It's basically broadcast. So the jail officer will do that. I mean, so
Which is less than the report.
well, correct or wrong. It may have less speaking, but it also has viewing. It has who's conducting the interview and the questions, and who's actually asking the questions and everything. So it has, in that sense, it has more.
Does it have commentary on top of what was actually said? Is that what?
It basically has basically the video of Mr. Carnes sitting at a table with the call coming in and him basically asking the questions, him, the defendant talking and Mr. Carnes asking questions back and all that other kind of stuff. It's not just, so in that sense it shows more. Obviously, jail stuff is just audio. That shows who's doing what. I just want to make sure you're clear.
Let me try to summarize what I think, and I'll let you out here. So, what you're telling me is, as far as the telephone conversation with the phone, there is a recorded conversation that was not played in its entirety on the broadcast. But on the broadcast, there's part of the recorded conversation and some extra commentary or comments.
Well, no, sir, that's not, what I'm saying is, I think what is there is pretty much the recording. The telephone call ends, and Mr. Carnes is basically, they're videotaping him do this. This is what was published on the internet as well as broadcast and otherwise. Now, when they broadcast it, they may have a short version, but it's basically on their website. Basically, what you've got is him sitting down at a table conducting, with the defendant calling in, and him basically having a conversation back and forth with the defendant, and it goes in its entirety, as I understand. So, if there's something before that, there could possibly be something, before that on a jail call, but as far as that broadcast, it's basically what was there. It has Mr. Carnes there. There's not commentary after that by Mr. Carnes that I'm aware of. I'm talking about the part where he basically calls in and he has a conversation with him and it goes for whatever period of time.
Bring them on in.
I think the issue is he wants white
Bottom line is way, if I had to invest in way, that's what you got to do is way. We're basically talking about the way it's way.
Okay. Those 2 minutes you're talking about, now you got it.
Your Honor, the issue, I guess, is it additive to a material issue in a case to have video of a reporter talking to a speakerphone with Mr. Hood's voice on the other side, as opposed to having just the audio, and actually a more complete audio transmitted to that call. And you've got to have a higher showing of materiality and relevance. And I think this is so distant from any issue that's actually in the case anyway. But even if it somehow was relevant to the case, that Mr. Hood gave an interview to somebody while he was in jail, you got to show that making the reporter sit in that chair and say, yeah, that's me in a video, adds something of significance to the trial and is necessary to the state's prosecution to justify overcoming a First Amendment privilege that is intended to prevent the media from having to be put in that position. And that's what's not present here. The jury can get, and the state can get everything it wants, the substance of the communication, which is the only thing that could possibly be relevant to any charge in the case, by the audio. Having video of a reporter sitting there having the conversation is not sufficiently additive and material to overcome the privilege we would submit. Thank you.
I heard what Mr. Malden said about not interrupting Mr. Carnes' vacation. There's no need for me to get involved in that, but here's what I want to make clear. If the subpoena is not quashed, if we get to that point, we would not be waiting because he was not here. He's subpoenaed, so that's his call about that. But I just call on the record. I just didn't want to leave here thinking that I've addressed that issue. And I won't, I'll look at it in the next couple of days, but I won't have a chance to look at it today or tomorrow.
Mr. Carnes understands the reason the motion was filed when it was, and presented when it was, when Mr. Malden and I have been working as cooperatively as he could possibly under the circumstances to deal with it, and both of us were hopeful we could deal with it closer to the time when these witnesses were likely to be called or resolve it at that time. I only learned yesterday that Mr. Carnes was planning to leave the country, and that's why we felt like we needed to get the motion on file. He's aware of the requirements.
And I'm not preventing y'all from continuing to work on that, and if you do resolve it before I spend 3 hours looking at it, I appreciate hearing about it.
Thank you. We'll continue to try to do that.
So, thank you.
Thank you.
Thank you for your presentation.
Is it flashpoint? That's one that's one.
Do you have any other information on the first amendment? Talk about Georgia statute. If there's anything else you want to see me on the first amendment, that
All right, we can supplement
save
that.
some time.
Thank you. And if you excuse me.
Yes, thank you, Judge.
Thank you.